All rise. Lake Circuit Court is now in session. The Honorable Judge George C. Ferris presiding.
You may be seated. Morning, Honor. Good morning. Good morning. We're here in the matter of Nicole Baldwin and Brian Baldwin versus Siebes Sales and Engineering, Inc. et al. Let's see what we have. BJ Auto and Restoration, Roy L. Nagel, Richard Micah, and RJ Micah, Inc. Are we here for a final pretrial?
Yes, Your Honor.
Are we ready to proceed?
Your Honor, we do have a pending motion.
Which motion is that?
A motion to exclude the testimony of Dr. Trumbull and an alternate relatively to jury trial.
You want to go through that one?
Yes. Yes, Your
All
Honor.
right. Let's hear it.
Thank you, Your Honor. Your Honor, I'm Francis Feltry, and I represent Roy Nagel and LakeCo. This case, just a brief recitation of the facts. This is a slip and fall that occurred back in.
Right. There's a dispute over where she fell.
No, Your Honor. I'm just to mention.
Or dispute whose property she fell on.
Yes, there is.
Okay.
But there is a question as to where she fell. Yes.
All right.
But the key portion of this motion is that we had scheduled and took the deposition of the plaintiff on January 24th, 2014. At that time, plaintiff advised that in October of 2013, she was on a field trip as a teacher's aide when she tripped over a corn stalk and ultimately had a surgery that, while had been proposed by a treating physician earlier, she chose not to have that surgery until after this October 2013 incident at a pumpkin patch. This reason it's significant, Your Honor, is that this is the first time we were made aware of this situation and would like an opportunity to investigate the matter. Even though that there had been a recommendation of surgery, that recommendation by Dr. Aker had included a proviso that was purely at the whim of the plaintiff if she wanted to proceed with the surgery, which she did not choose to have for over a year and a half. She then decides, after this incident, while employed by the local school district, to have the surgery. And this affects the plaintiff's case and defendant's case to respond, because plaintiff doesn't have an opportunity to determine what relationship this other incident, this new incident, would have in regard to her medical condition. So that was significant, and also provides us with an inability to adequately defend this case if we are forced to go to trial at the present date.
All right.
This is a joint defense motion, so would you like to hear? Okay.
Sure.
I just wanted to add a couple of things. Would you like me to take the podium, or is it okay?
Wherever you want.
Thank you. Just add a couple of things. If we back up a little bit, in November of 2011, in supplementation to discovery responses, which specifically asked what treaters do you treat with, on behalf of plaintiff's counsel, Dr. Akery, who had been primarily treating the defendant or the plaintiff through 2012, issued a report, and at that time issued the following opinion: at this time, I do not think any further treatment is needed, except possibly.
Now, which doctor is this again?
This is Dr. Akery, who was identified.
Okay.
And has been identified since the original witness and contention submission back in June.
Okay.
So for some time. At this time, I do not think any further treatment is needed, except possibly an orthotic, which could range in the area of $5,000 to $10,000 if custom made. Now, in January of this year, we received some additional discovery, additional documents, medical documents, from Dr. Akery, purporting to be a visit of September 20th of 2012. And at that time, Dr. Acree says, well, she may need an ankle fusion in the future. January 24th, we then took Dr. Acree's deposition. And Dr. Acree said, yes, she may need one. Now, it wasn't definitive. She hadn't scheduled it with him. And this was about opinions he had rendered back in September of 2012, so over a year before. Also on January 24th, during...
So was he of the same opinion back in 2012 that she may need ankle fusions?
Dr. Acree? Yes, he was of that now. During Dr. Acree's deposition, however, the question was asked of Dr. Acree, were you aware that Ms. Baldwin is now treating with Dr. Trumbull, Scott Trumbull? First time his name had come up. He was shown a one-page medical record, which purports to be from a visit January 14th of 2014, so 10 days before this deposition.
What kind of a physician is Trumbull?
Dr. Trumbull is it says he's a DO or an MD, and he's got to be orthopedic because he's the one who did the ankle fusion.
All right.
We have this one page, and it says, not reviewed by provider to expedite release. It's a one-page document, and it talks about the fact that Dr. Trumbull is of the opinion that she's going to need this ankle fusion. Now, January 24th is the first time that we knew of any treatment with Dr. Trumbull. We knew that she had ever gone to Dr. Trumbull, and in fact, she started going to Dr. Trumbull, according to her, in December of 2013. And yet, it's January 24th when we're first hearing of his name through the deposition of another doctor.
When did you say she started seeing Dr. Trumbull?
Sometime in December of 2013. We do not have any other than this one page.
A month before you had noticed that she was seeing him.
Presumably, yes.
Okay.
And the reason I say presumably is other than this one page, we don't have any other records from Dr. Trumbull. They've been requested, as I understand, by both plaintiffs' counsel and my office, as well as the other defendants, and nobody's received them yet. Now, the problem with that is, of course, other than this one page and other than what's been testified to by Dr. Acree, we have no idea what Dr. Trumbull says. We also have this subsequent incident involving the corn stalk, and we do not know what significant that is with regard to the surgery that she had. And despite plaintiff's counsel's indication that the fall over the corn stalk was no big deal, the plaintiff herself says something a little different during her deposition. And specifically, she was asked the question, did you feel, this is on page 148 of her deposition, and I'm more than happy to submit the entire deposition to Your Honor. Question, did you feel any more pain since the October 2013 incident in your right ankle? Answer, of course, I felt. Question, has that pain always been the same since October 2013, up until the present, or has the pain actually worsened? Answer, I couldn't say. I hadn't really thought about it. She's then asked about her describing her pain and whether or not it's gotten worse since that accident, and her answer is, I honestly don't remember. It could have. So the plaintiff herself cannot tell, and she's not a medical doctor, we understand that. The plaintiff herself can't tell us the significance of that fall. It is alleged that it didn't do anything to the ankle, but it was the same ankle. And it's after that fall, and over a year later, that she actually has to have this surgery. Discovery, of course, is closed. We do not have the records. Didn't learn about Dr. Trumbull or any of his treatment until January 24th of 2013. Here we are less than a month later. We still don't have the records. And yet, plaintiff's counsel wants to both introduce all of that evidence to the jury, associate that with the accident at the parking area amongst the defendants, and somehow suggest that the defendants will all be prepared to defend against that. Because Dr. Trumbull's deposition has been set for March 6th. And we then have 18 days to do something with whatever testimony he provides. Now first, that's an evidentiary deposition. So his testimony will be in the can. And without the records, without being able to examine the records, and without being able to figure out what's going on between the subsequent accident and the surgery and how it all relates to the initial accident where she fell, we won't be able to cross-examine Dr. Trumbull. And 18 days after that deposition, assuming we've gotten the records by then, is certainly an insufficient amount of time for all of the defendants to get those to an independent expert if necessary, have those evaluated, and be ready to present that to the jury. I would suggest that the plaintiff cannot have his cake and eat it too. So if he wants to get in this information, then we have to have time to evaluate it. Otherwise, Dr. Trimble, his testimony, and anything about the ankle fusion should be excluded, and then we're all ready to go on all of the information that we had that was timely disclosed.
Counsel.
As Paul Harmon would say, and now the rest of the story. This is a fall that resulted in a severe fracture of an ankle. Throughout the course of this entire litigation, counsel have acknowledged severe fracture. All of the medical records have been provided. 4 surgeries have taken place on this ankle. And in September of 2011, Dr. Acree's last visit, and I'll read it to you, will likely need ankle fusion in the future. September 20th, 2012. I said 11, I misspoke. 2012. So everyone knows and acknowledges the severity of the fracture was such that post-traumatic arthritis was occurring. Everyone, defense counsel, in conversations, it's not surprising at all because of the severity of the fracture, the post-traumatic arthritis, that a fusion was going to occur, and in fact it's supported by the records. Now what happened in September of 2012, medical doctors like to be paid for their services. Nicole Baldwin had no health insurance. Because she had no health insurance, she had an outstanding bill with Dr. Acree of over $20-some thousand. Dr. Acree, in his last visit, is basically saying, I'm not going to treat you anymore because there's an outstanding bill. Fast forward, she gets a job with the Penn Harris Madison School Corporation. As a part of that employment, she gets health insurance. Now she has health insurance. Now she can get that surgery, which everyone knows and acknowledges because of the severity of the fracture and the existence of the post-traumatic arthritis, is going to take place. The law allows for, if she didn't have the fusion, Dr. Acree could testify, in my opinion, it is more likely than not that she will need to have an ankle fusion in the future. That is consistent with his office note of September 20th of 2012. Future medical expenses, future medical treatment can in fact be recovered. So the fact that she actually goes and gets that which Dr. Acree says is going to happen in the future, it's kind of a red herring, I would suggest to the court, because everyone knew that it was likely she was going to need an ankle fusion. The whole thing with the fall over the cornstalk, she went with a group of students to a like a corn patch. It's where I've taken my grandchildren before. And there's corn stalks, and you're able to go through the rows that are in the corn stalks, and you can pick out signs trying to find farm animals, trying to find all sorts of different things. It is an activity for kids. She rolled her ankle as a result of a cornstalk. That's all it was. The rolling of the ankle, we've requested those records once I found out about it. And I told the council, once they're obtained, I have no problem providing them.
What about Trumbull's records?
Trumbull's records have been requested too. The thing about Trumbull is this. There was a visit in December, an initial consultation, because finally Nicole has insurance, and Dr. Trumbull is an orthopedic surgeon at OSMC, which is Orthopedic Sports Medicine Corporation. Over in the St. Joe, Elkhart County area, there are two large orthopedic groups. South Bend basically has South Bend Orthopedics, SBO. Elkhart County has OSMC, Orthopedic Sports Medicine Corporation. She went to see Dr. Trumbull at OSMC for purposes of looking at the ankle, visit in December. CT was ordered because the doctor's not going to do anything without getting a recent CT. A visit occurred on January 14th of 2014, where the CT results were reviewed, and it was recommended at that time that she have the fusion that Dr. Avery talked about in September of 12, that everyone has acknowledged because of the severity, she's going to end up needing anyway. Trumbull's records have been requested. Upon receipt of those records, I'm more than happy to provide them. They're entitled to them. But the bottom line is, what Trumbull is doing is nothing more than what the doctors all along, what Dr. Avery has said all along she's going to need. Because all the fusion does is eliminate the pain that is resulting in the joint because of the traumatic arthritis. It eliminates the pain, eliminates mobility, but it also eliminates the pain. Okay. So whether we talk about actual fusion taking place or Dr. Avery saying, in my opinion, it is more likely than not that she's going to have a fusion in the future, with future medical treatment, when cases take 5 years to proceed, because we're now 5 years plus from the time of the fall, when they take that long, many times the future medical care and treatment actually comes about. And the reason Dr. Avery did not do the surgery is because he wouldn't see her anymore because of the large bill. She then got the insurance. So
my question is, when are we going to get them the records?
I have requested the records. They have been prepaid. My office is calling for those records every day.
I mean, you have his deposition, I see, set for what, March 6th or something?
I would expect that by Tuesday or Wednesday of next week, we will have those records. It's, you know, this isn't the type of injury where there is strong difference of opinions that doctors can have. It's not a soft tissue type of case. It is a broken bone traumatic arthritis. You know, the need for an independent medical.
Well, they need the records to take the deposition.
I agree with that completely.
Okay. So we got his deposition set for next week?
Set for March
6th.
I mean, March 6th.
Deposition. That's, yes, Mr.
So what other preparation do you need to do?
Well, Your Honor, if I may add, the other issue is that Dr. Trumbull is also going to speak, I would assume, about not only the surgery itself, but any sort of permanency and or future medical. And clearly, the discovery is closed. So on those issues, I think any testimony has to be precluded. Because, again, there is no evidence to support any permanency or the future medical needs of the plaintiff that's been provided while discovery was open. So I believe that even getting me the medical records now, after discovery is closed, is prejudicial. And so if we can exclude permanency and any testimony on future medical needs, then I guess that we can proceed with the deposition of Dr. Trumbull.
They have known permanency is an issue forever. That is not something that just came out of the clear blue. Acri talks about permanency. Acri talks about the more likely than not that she's going to need the fusion.
Your Honor, I have to interrupt you, Dan, because that is not what Dr. Acri stated. He said his opinion now that she was having the surgery on permanency was speculative, and I apologize for interrupting.
He didn't say his opinion was speculative. He never said that.
He said he could not provide any sort of permanency opinion, and that's what he said. I mean,
He said permanency rating. Permanency ratings are workman's compensation issues. They are not, I don't ask doctors for permanency ratings.
But he still could not give you an opinion on any type of permanence.
We've got an ankle fusion surgery here, an broken ankle. Is that what we have, fractured ankle?
We have a broken ankle.
Don't we assume that there may be some permanency there?
Well, we don't know.
There may be some, but we don't know the ultimate outcome, especially given the fact that there's an intervening incident in October at the pumpkin patch.
Well, those are issues for the jury to
but we should be
sort.
But we can't investigate it, Your Honor,
Why not?
because we didn't know about it until January 24th.
Well, when did it happen?
October 2013. And also, if I may add, given...
What kind of investigation are you talking about?
Well,
Going out
plaintiff
to
should
pumpkin patch?
disclosed that when it happened in October of 2013, that she had an incident that affected her, that she then needed surgery. She received care at an urgent care, which we still don't have the records for as well.
Isn't that something you should ask the doctor?
The doctor, but I can't have, I'm asking the doctor blindly. I still don't have the records, and I still don't have the urgent care records of the treatment that she received.
No.
And it's...
Well, I agree, you need those records.
Well, in addition to getting the records, the defendants need an opportunity. We're just a few days over a month before trial. And we still don't have all of this documentation. We will now have to get the records, have the records reviewed both by ourselves. I'm not a physician, and I don't have, apparently, the medical background that Mr. Pfeiffer has to be able to say whether or not this trip over the cornstalk was a big deal or not. I need to have that reviewed by a doctor. So I'm going to have to get the records. I'm going to have those reviewed at a rush cost by somebody who knows what they're talking about. Then take his deposition, then get all of that material over to an expert. Now, keep in mind, discovery's all closed, expert disclosures are all closed. Get those over to an expert so that I can be prepared to defend against those in front of the jury in what will be less than a month, 18 days after Trumbull's deposition is taken. That's an unfair advantage that the plaintiff is trying to capitalize on, and this is all at the last minute, trial by ambush, and to make the defendants scramble to deal with all of this definitive information is simply unfair. And I disagree that Dr. Acri definitively said she was going to have anything in the future.
Well, that's something that the jury will sort out,
Well, I know.
whether she had to have something in the future. You examine the doctors on the stand.
I understand that, but we can't go in to examine him blindly. And the
Did
defendant
you take his
should be able to-
deposition?
I did, and learned for the very first time about the fact that she's having had this surgery.
They never took a discovery deposition of Dr. Acri. The only deposition that has been taken was taken by me. In November of 2011, in a report that Dr. Acri wrote, he says she has a permanent condition.
But he doesn't say she's going to need to have a surgery. All he says is she needs narcotics,
September of 12.
which we got in January.
You know.
Yes.
You sent... I'm sorry.
What in January?
September of 12. He says she will likely need a fusion. Now, nobody ever took Dr. Acri's discovery deposition. Nobody. And I suggest to the court the reason that wasn't done is because of the very nature of the injury. This is not like a soft tissue where doctors can disagree. Nobody ever did anything with Dr. Acri. This case has been scheduled for trial one time before and got continued. And I can't remember the reason for the continuance. But the bottom line is, if we had gone forward at trial at that time, the fusion would not have taken place, but Dr. Akery would have said, likely that she's going to need a fusion.
And we have my medical expert is going to testify that that's speculative and you can't say that.
I don't even have a report from your medical expert.
Because you didn't serve me with any expert discovery.
That is not,
I don't have a report, Dan. I don't have a report.
I
have
asked you
nothing
for
to give you.
opinions for any experts
I
that you
have
guys.
no reports.
I asked you for opinions, not reports.
Did you
Opinions.
disclose your experts to him?
I've disclosed them. They're listed in the pretrial order. Absolutely.
70-some witnesses listed in a pretrial order. 70-some.
In my witnesses, he's been disclosed since June.
They have never, ever, ever given me any indication whatsoever that we have an expert who's going to say this.
So you
This
have
is the
an
first
expert
time
that's
I'm
gonna
finding out
testify.
about it.
I do have an expert who's going to testify. Now, his opinions are going to be completely outdated given all of this new information. It's not speculative anymore. She had the surgery.
I'm done.
I don't, and I
So
don't
you have an expert that you can provide these materials to?
I do. I just need time to do it. 18 days isn't enough.
18 days is fine for me to take their expert's deposition. I'll do it.
And you disclose his name so you can take his deposition?
His name's been...
And his opinions, Jennifer.
Well, I will be more than happy to do that. I had no discovery response to respond to. None.
None. And I didn't bring my whole file because it's basically 2 or 3
Are we
boxes.
supposed to disclose our experts and their opinions?
Yes.
I'm just supposed to disclose the experts according to Your Honor's pretrial order. I did that.
Did they disclose him as an expert?
I got a list in the pretrial order, and the pretrial order was filed February 11th. And in that pretrial order, there's 59 witnesses, 59 exhibits. Any reports prepared by any expert witnesses. That's an exhibit that they've all listed. In terms of names, we have defendant C. They have, it goes to double K, so A through Z is 26, and then another 2, 4, 6, 8, 10, 11, 37 witnesses, all of which are healthcare providers. Dr. James Correcia, Dr. Mohammed Khan, Dr. Allison Lemberg, Dr. Karen Mahalik, Dr.
Are they treating physicians?
I'm not defendant
On
C, so
behalf
I
of C,
can't.
they were treating physicians, and I don't think we're going to.
Which one is the expert?
Well,
Defendant C does not have a medical expert guard.
Which one is your expert? that you
Dr.
just-
Thomas K. Number 10 out of specifically identified witnesses out of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Out of 12 witnesses, he's identified. He's not a treating physician. He's number 10. He's been disclosed since June.
Dr. K was never disclosed.
I will show you the submissions.
June.
Yes, he was. Preliminary, witnesses, and exhibits.
All right. You've got his deposition scheduled March 6th. I presume you're going to take the deposition. You're going to get her the records prior to the deposition.
I'll get the records by Wednesday of next week. If
Okay.
I don't have the records by Wednesday of next week,
It's
I'll be the
it's
first.
another ball game.
I'll be the first to say, fine, continue the trial. I'll do that.
All right.
I've been doing this for 35 years, Judge, and I have never once until today been accused of trial by ambush. And I'm sorry, but my blood pressure gets going over something like that.
All right. You're going to take deposition on the 6th. You'll provide him with the records by next Wednesday is what, the 26th?
And could I get Dr. K's opinions?
And you
After I find out all the stuff that...
You just said he has opinions.
Well, they're gone now, Dan. I now have information from you, from no doctor,
you have
but from
opinions that
you.
he's provided to date.
I know, yes, I have opinions that he's provided to date.
And then you're-
None of those, though, can be presented to this jury because they're no longer valid. I now have a subsequent incident, I now have a new treating physician,
He's still
and I now
entitled
have a
to them.
surgery.
he's still entitled to.
Of course,
Okay, so you'll provide those by the 26th?
absolutely.
Okay.
And then we'll take his deposition.
You can. I won't be able to call him if, in fact, Dr. Trumbull is allowed to testify with all of this new stuff. I don't have his opinions. I don't know what he's going to say. And the deposition that's going on the 6th is evidentiary, as was Dr. Acree's. Those will be in the can. These are not things that we can learn and use to discover information. The fact that this information isn't disclosed until January 24th has put us at a distinct disadvantage. And perhaps, I know Seep Sales and the LakeCo defendants didn't identify an expert, but maybe they want to. I can't speak for them. It's difficult to analyze records and materials that are theoretical and that we don't have.
Well, you'll have them
Opinions.
take the deposition. If anything arises from that deposition that is something that we can't deal with, we'll address it again. Okay?
It's fair.
All right. Now, the next matter we have, the motions in limine. Other than this, are there other, have you agreed on all these other motions in limine? I looked at them, they seem pretty.
Well, the only motion in limine that I disagree with was Clark's office, where part of their motion in limine was to talk about permanency. I disagree with that. I mean, obviously, based upon what we've talked about. So I disagree with that part.
It would all be part and parcel of this same argument.
Well, we'll reserve it,
Yeah.
see what happens, okay?
He didn't have any.
The motion in limine by Mr. Veltri didn't have any. Mr. Moore had them on settlement negotiations and insurance.
Well, of course.
I never got yours. That's standard. I have no problem with that. Clark's motion in limine, and I can go through the points. There were
Hold on.
22 points.
There were, most of which are standard.
Right.
Number 1, defendant's liability insurance. No problem. No objection.
Negotiation.
Offer of compromise, number 2. No objection. Lay opinions as to causation. No objection. Witnesses' testimony as to what they were told by a health care provider. No objection. Expression of opinion within medical records. Doctors give medical opinions in their testimony. Evidence of future medical care. I do have an issue with that.
Which one are you reading from? Number?
I'm sorry.
Number 7.
Number 7 is future medical.
Same arguments.
Well, that one we're reserving.
8, references to discovery disputes and untimely production of documents. I don't argue that kind of stuff to the
Right,
jury.
okay.
9, references to motions filed by parties, and no objection. Golden rule, I don't argue. Golden rule. References to R.J. Micah, Inc.'s corporate status. I'm a little bit confused about that, because if we identify them as R.J. Micah, Inc., how can we then say it's R.J. Micah, Inc., but guess what, you're not a corporation?
No. If you actually read the motion, what this is going, they're a big bad corporation. They're trying to beat up on the individual little person. That's what the actual motion says, if you had read it.
What it says is references to R.J. Micah, Inc.'s corporate status.
Yeah, look at the argument contained within the motion.
I'm looking at the points.
Okay.
Okay, that's a title.
Well, aren't they a party? Is the corporation a party?
Yeah. The argument is nobody should be able to argue because
This is a big
bad
corporation.
and they're trying to beat up on the little person.
They're
They're not. I mean,
I'm aware they shouldn't even be
go
part of the case.
parcel with
it's a one-man
the financial condition of the party?
Right.
Exactly.
Right.
Exactly.
I don't.
All right, okay.
I have no problem with that.
Well, if it gets into that in trial, I mean, I don't think it will, but
Any disclosure of facts underlying the present.
Argument effects.
It says any disclosure of facts underlying. I'm reading it.
I know you're reading headings. Dan. You're not reading arguments. You're reading
disclosure of facts in the case during voir dire?
It's meant to be argument. Argument of facts in voir dire. If you heard this, this, and this, how would you think you'd decide that kind of case?
Oh, I don't.
Okay.
You don't do that.
Well, I know, but
Legal conclusions by any witnesses, I agree with that. Witnesses, exhibits, and contentions that were not found, we've already talked about that.
Okay.
Any illegible medical records, no one has ever claimed to me that any of the medical records aren't illegible.
I haven't seen all of the medical records.
Subsequent remedial measures taken
Well, on
by...
this illegible medical records, what if you have a doctor on the stand who can read his writing?
No, that's exactly what it's meant to require. That
Right.
if you have a medical record that
If nobody can read
nobody
it?
else can read, then the doctor has to
No.
say what it says.
I agree with that.
Okay.
I have no problem with that. Subsequent remedial measures, I don't know that there were any taken, other than to put a yellow line down.
What about, of course,
Yeah,
going
that's
to get
not
into
remedial,
prior
was it?
subsequent accidents or
People-
lawsuits at defendant's premises? You agree with
No,
that?
I have no problem.
Okay, all right.
And to the converse of that would be true. Nobody else has fallen. No one else has filed a lawsuit.
Right.
So
Of course.
it works both ways. So I have no problem as long as it works both ways. Send a message argument, financial situation, no problem with any of that. Use of defendant's confidential or proprietary documents. There have been not one document in this entire case disclosed as confidential or proprietary.
Okay.
Testimony of non-called witnesses. Any reference to testimony. It all depends. I mean, if there is the pattern instruction out there that allows for, you've got this witness that was listed by one of the parties and they didn't bring that witness in, you can infer. I mean, I can't say yes or no to that right now until
All right,
I know
we'll
which
reserve
is
it.
which.
See what you...
Just may I very briefly, the argument actually talks about precluding the argument had they disagreed that she's going to be permanently disabled for the remainder of her life. Don't you think they would have called a medical expert here to testify about that? That's what that
I think it's fair game that I can argue if they choose not to have an independent exam or they choose not to call an expert. I think it's fair game to argue they had the right to have an IME or a defense medical examination performed. They didn't do that. They have that right. We're talking about the right that they have that they chose not to exercise. I've argued that many, many times. I'll defer to the court, but I think that's a fair argument.
Under these particular circumstances, that is not a fair argument, especially given the late hour of this, if this trial is going to proceed. The fact that we have not now done an IME, if Mr. Pfeiffer is willing to allow us to do an IME at this late date, then, and we choose not to do so, then I agree with him, he can make that argument.
I have no problem whatsoever with you performing an IME if you choose. We're 5 years into this,
I'm aware.
and no one has ever asked for it, but if you want it, I'll make her available.
I think argument is argument.
I'm sorry?
Argument's argument. If he's going to argue it, I mean, if you said you have an expert too.
I do, and I appreciate the offer. I will consider the offer. I, in all honesty, need to see what I don't have yet, have that evaluated and make.
We'll reserve that for. Any comments from counsel on parties' failure to call certain experts?
It's the same argument, Your Honor.
It's the same argument, yeah.
Okay.
Mr. Velkrieg just handed me his.
Which were filed, Your Honor.
Defendant
And
Roy
this is
Nagel.
which,
Roy Nagel and LakeCo.
Looks like it's certificate of service.
pretty much same stuff, right?
It is pretty much. 1 is fine, 2 is fine, 3 is fine, 4 is fine, as long as, again, both ways.
Sure.
Mm-hmm.
5 we've talked about 5.
Yeah, that's
6 is fine. 7, not qualified, is fine. 8, fine. 9, fine.
it.
That's it. We have, the other one just had two, which are duplicative. Settlement negotiation and CVAD insurance. Is that it?
It is.
Your Honor, would you like my office to prepare a one order with regard to the rulings on all of these motions in limine?
You can.
I have a chart order that I submit that just puts them in there and says reserved, granted, without objection, whatever. I'll submit it to you for your review.
Yeah, that's fine.
All right. All right, any other preliminary matters we need to go over?
Just one, as part and parcel of this motion with regard to Dr. Trimble, I have also prepared a motion to amend the pretrial order. Somehow Dr. Trimble is listed in that pretrial order. He wasn't submitted in any prior version, except for the one that was actually filed by Plaintiff's Counsel's office.
Oh, no. I'm sorry. He is identified by Adam Moore as a witness.
No, he's not.
Yes, he is.
Can you show me, please?
I will.
I prepared it, though. I don't know why. I don't know what.
He identified him as a witness.
Show me.
I don't have.
Oh, number 14 for defendant. Wait a minute. 14 is ours. That's ours.
I agree that you identified him.
Right. Oh, all treating, okay, they list all treating witnesses, or all
Okay.
treating physicians. Okay. I'm sorry. That's ours, not theirs.
Hey, don't you know?
Yes, I'm the bailiff.
Oh, I need to do the original, which wasn't on me.
What is
Yes. Motion to amend the pretrial order to remove Dr. Trimble, postpartum parcel of the ambulance that we just made.
Are you suggesting that I added Trimble's name after this was signed?
No, I'm suggesting you
It was
added
signed
it
by
after it
everybody.
was submitted to everybody.
No, it was signed by everybody with Trimble's name on it.
Did you identify, when the version that was sent out the night before
Yes.
did not have Trimble's name?
Yes, it did, and I told your Bruce's son that his name was being added. I told Francis that his name was being added, and I told Adam that his name was being added. You weren't at the deposition when this discussion took place.
You're absolutely right, it wasn't, which is why I
Absolutely
asked Mr.
told
Beltry,
everybody.
I asked Mr. Clark, and I asked Mr. Moore if he was identified. All told me no.
Francis and Adam, you guys look at me and say that I never identified Trumbull as a witness.
You identified him.
Okay, and that he's going to be
The
included.
deposition, you were including it, but the version of the pretrial order with him included, I'm trying to explain.
Nope.
And I'm not trying to testify, I'm trying to explain. When I arrived, we took the deposition at Mr. Pfeiffer's office. There was a prepared pretrial order that I signed. I admit that Dr. Trumbull's name was on that pretrial order.
Okay.
I will also state that I don't know if anybody else had seen that version, because there was a version there that I don't know if anybody else saw.
I told you, Adam, on the phone,
And, Your Honor, I will represent that I gave Dan authorization to sign my name at the pretrial.
with Dr. Trumbull's name in there.
I don't remember. I have no reason to doubt Dan. I worked
Okay.
with him for years. But the same token, I'm not saying anything bad about co-counsel.
I do not add names after signatures are put on
I'm not saying you
documents.
did it after the signatures.
Oh.
I don't believe you did.
Well, he's in there, and we all know about him. And we've got his deposition scheduled, so
Instructions?
Oh, yeah.
I didn't know if you wanted to.
we need a disc too with these.
And I apologize. That
You
was on the
give us
other
one,
day. I
yeah.
will. And here's the
What are we doing?
CCS that shows
Instruction.
instructions and verdict forms.
Okay. Now, one thing I'd like you to do is if you both can work on you can all work on an issues instruction. Sometimes I don't like reading them from the pretrial order of contentions, because sometimes it's by the time you get to trial, there's stuff in there that, I just had one where, they said, read it for the pretrial order. Well, they asked for treble damages and this and that, then I get to the trial, and there was not a word mention of it.
They're going to hear our opening arguments anyway.
Yeah.
I have instructions also here.
So if you could work on an issues instruction, a preliminary issues instruction, something you may agree on. If you can't agree, just give me what you both have, and I'll put it together.
Your Honor, I would ask for leave to, I wanted to review the jury instructions. I don't have my own.
All right, you can submit them.
Thank you, Your Honor.
Sure.
Yeah, I just want copies with the documents.
All right.
Parties who are not here.
Which one? Pretrial order?
Anybody else?
Okay.
Yeah.
Okay. Do we anywhere with settlement to go? I don't know if I should even ask the question, or where are we at with settlement on this case?
Where we're at is leading up to the time that pre-fusion medical bills were $42,000, lost wages were $46,000. Now that the fusion is taking place, I don't know what the Stanley number is, and I don't know what the gross number is. I'm presuming, just based upon experience, there's probably another $15,000 to $25,000 for the fusion in terms of medicals. We went to mediation, and I think $5,000 was offered as a joint proposal. Mr. Veltry's been trying hard to, as he and I have said, herd the cats and get a proposal together. He's not, the cats are too frisky, and so he's not been successful in herding the cats in this case. He's offered $20,000 and said basically,
That was actually private.
oh,
No, it's all right.
oh, I guess it's not even.
No.
So, I mean, we're always ready, willing, and able to settle.
What did you demand? What was your demand?
The demand was, at the mediation, I think I went down to like $425 was the demand.
$425?
$425.
And they offered a total of 30?
They offered a total, actually all that has been offered right now as we stand here in court is Mr. Veltry's 20.
And he has 15 as a QSA.
And we put that up.
Okay, so 40.
40. Is there any chance of this getting settled?
May I make an inquiry of counsel?
Mm-hmm.
Is the demand going to go up given the fusion?
Well, no, the demand of $425 is not going to go up.
Okay.
No, that is not going up. No.
Slim, but perhaps.
Okay. All right, we covered pending. So how many witnesses are we really going to have?
Yeah. You want to address that?
I can address, there will be 2 plaintiffs,
Mm-hmm.
2 doctors by video.
Mm-hmm.
That's 4. 2 Siebes, Canopalis. That's 7. Nagel, 8. Micah, 9.
Rest?
Jim Rez, I don't know if he shows up.
About 10 witnesses?
10. I'm guessing by the time everything is said and done, we probably won't have more than 12 to 13 witnesses. I'm trying to just give us a little bit of wiggle room.
Is that combined?
That's everybody.
Everybody.
I think I'd be at a more for Steve. I think I'd be able to do whatever on cross, so I don't think
Right.
we'd call.
How about, do you think it'd be need to recall these people?
Recall?
After, he's calling the same witnesses.
No, I anticipate having one witness in addition to those people that
Okay.
council will call.
Your expert.
Yes.
I forgot about it.
The only thing, Your Honor, given the willingness to have an IME, I did have a consultant, a medical consultant involved, who I've not disclosed, that I may
So we may have 15 witnesses.
possibly. Your Honor.
And we're set for 3 days? We're going to get it done in 3 days with 15 witnesses?
I think of the 15 witnesses, plaintiff misses, 2 doctors, and then maybe the other doctor.
Yeah.
Those 4 witnesses would be the longest. I think the other witnesses are going to be probably, even with 4 attorneys, 45-minute witnesses. Their depositions took longer, but we got into a lot of juicy stuff that we probably can't get into at trial. So I don't see them taking that long. Nagel and Sieb and Conopalis will probably be the longest. I don't think Micah's going to be long. So. Then
3
we got
days
to-
is pushing it on this case, I'll tell you that. Probably go 4.
3 days is probably pushing it.
It could be.
Well, we can go 4 if we have to.
What's up?
We can go for it.
All right, exhibits. I guess we have a lot of them. Do we?
Yes.
A medical chronology, I believe, has already been provided.
I mean, are we stipulated, will most of the exhibits be stipulated to?
Yes.
To where you can provide them in one binder to the jury?
I think that.
Yeah, I don't
Yeah.
see a problem with that.
I mean, from my end, Your Honor, of course, also, I think I want the photos of, there's a dispute on where the plaintiff fell and who owned what. So I think the photos is probably something I'll be putting in. I don't know if there's much medical that have gone in. I don't know what will happen at Trumbull's.
Well, is there a dispute as to photos?
No.
I think they're in the depths.
There are no, any exhibit that has been disclosed in terms of medical records or in terms of leases or photos, any of that that's been disclosed, there will not be an objection from the plaintiffs for the admissibility of those.
We could put
Okay.
the book together.
I would think that we could put a book together.
All right.
And the only additional exhibit that hasn't been disclosed, could be more for demonstrative, would just be simply a Stanley versus Walker chart, which I'm sure we could agree to.
Right now, there's
hasn't
no
been
Stanley
prepared.
issue because there was never any insurance until just recently.
It's why you mentioned, I don't know what the Stanley numbers are. It's why I say
I
that.
don't know. Yeah, a Stanley chart is fine, gross and net.
Yeah, exactly.
All right. We have the instructions and verdict forms.
With respect to
Voidar,
the verdict form, Your Honor, I threw this out before the court took the bench. There are, I think, 7 or 8 defendants who the jury could allocate, 7 or 8 individuals, corporations, that could be allocated some percentage of fault. I suggested to defense counsel, we asked the jury to allocate the percentages. We asked the jury to do the total damages. And then either we, by stipulation, or the court, do the math. Because when you have so many people, the mathematics of figuring 15% or 20% of the total damages, that becomes sometimes a concept that the jurors fumble with. And so it's nothing more than implementing the decision of the jury. They determine the total damages, they determine the percentages of fault. All we could do is, or the court, is just do the math to implement the decision that they made. So.
Well, there's an
I threw that out.
instruction on telling them how to do the math.
I'm sorry?
We have an instruction on how to tell them to do the math.
I know, and I
I mean,
know.
I mean, we start getting into that, or we invading what the jury should be deciding.
I don't think we're invading what their jury should be deciding. They decide the percentages of fault, and they decide the damages. And the verdict
Don't they
form,
decide what, in other words, you're saying they decide what percentage to assess to each defendant, and then we do the math.
exactly. That's all I'm saying.
Well, let's wait till we get to, let's
Okay.
see about that at trial.
We might get a panel full of mathematicians.
Yeah, I mean, I've had some complicated issues where the jury seemed to sort it out pretty good. Do the math. We give them a calculator.
But one other logistical question. I know we've
Okay.
talked about this whole issue of the Dr. Trumbull and everything else. I don't want to beat the dead horse. It seems like the motion to amend the pretrial order that was just filed today basically deals with that very issue. They want to take Trumbull out of the pretrial order. We've talked about all of that. Trying to avoid killing more trees and giving even more paperwork to the court, trying to avoid that, is a response to the motion that was filed necessary, or have we dealt with it sufficiently?
I would agree that we have dealt with it sufficiently. Your Honor,
Okay.
whatever Your Honor ultimately rules after we get it all done will also encompass exactly what was addressed
All right.
in the filing today.
Okay. All right, on Voidire, I just asked the panel as a whole, a few questions. We bring them up 6 or 7 at a time. I don't know if you want the alternate deliberate or not. I mean, you can make that decision now, or you can make it at trial.
I have to make it a trial, Your Honor. I have to get permission.
Okay, usually the last juror we call is the alternate. Okay? I usually bring up 7 up at a time just to move it along. And the last one standing or the last one chosen is the alternate.
Each side, plaintiff gets 3 strikes,
strikes.
defendants collectively get 3 strikes.
I don't know. Collectively, yes.
Yeah.
Okay?
So play nice with each other.
That's what I just said.
All right, time limits, I don't usually put any time limits on your Voidires lot.
No.
I haven't seen anybody be unreasonable with it, I've already talked about the alternate, manner of selection. We bring them up, we load up the box, and then we go from there.
One pass system, once they're passed, they're in.
Pardon me?
One pass system, if you pass them, then they're a juror.
They're a juror.
Okay.
If they're not struck preemptively or for cause, they're a juror.
Okay.
Opening and closing statements, what kind of time limits are we looking at?
I would think at most 30 minutes, probably I could do it in 20, but 20 to 30 is all I need
For opening?
for opening.
And that's fine. We can split it up 10-10-10.
Good? Okay.
And closing, if we could wait to decide that after the evidence.
All right. I guess we could do that. All right. The way I as far as breaks and time schedule, take a break in the morning, take one in the afternoon, a break for an hour for lunch around noon, or, in that time frame will the last conclude the testimony of a witness. And I try to conclude the evidence by 4:30 at the latest.
And what time will you start?
9. Are you going to require or set up any audio-visual material?
Yeah, I'll need video.
Okay. Do you have your own?
I have a television that has a DVD player built into it, so I
Okay.
can bring that.
Okay.
And if there's going to be any PowerPoint, we'll have the
Right.
projection equipment that we need. If we're going to do a PowerPoint, I'll make sure that a copy of the PowerPoint presentation is provided to Defense Counsel before it's used. I would just ask for the same courtesy, or if the court directs us to do that, that would be great.
I won't have a PowerPoint.
Okay. And if you wish, you can come in that Friday evening, afternoon, and set up
Okay.
for Monday. Okay? All right, any other matters we need to cover?
No, Your Honor.
Okay. Right. So you'll be deposing the doctor, and we'll go from there on that issue. And we're set for the 26th, or no,
Great.
24th?
24th of March.
Thank you.
All right, anything else? Okay,
No,
thank
Your
you.
Honor.